All rise. Florida District Court of Appeal, First District is now in session. All those with cause to plead, draw nigh, give attention, you shall be heard. And God save these United States, the great state of Florida, and its honorable court.
Be seated. Morning, ladies and gentlemen. Welcome. We will hear the cases that they appear on the order of the docket, and after the first case, we'll take a break in the Dean's conference room, and we would invite you all to join us for coffee. The first case is National Indemnity Company. Counsel, ready to proceed?
Yes, Your Honor. May it please the Court, I'm Michael Korn and Zimmer. On behalf of the appellants, along with Greer Wells and Sheldon Stevens, I would like to reserve 5 minutes for rebuttal, please. This case presents numerous issues. I suspect we will not address all of them. The case emanates from a 2-long trial where the plaintiff sought damages for alleged fraudulent misrepresentation in connection with the settlement of certain wrongful death claims which had occurred several years earlier. The case was hotly contested both on the issue of liability and the issue of damages, and numerous issues result from this both for appeal and cross-appeal purposes. The case, although not supposedly tried on the basis of the underlying automobile collision which caused the tragic death of the plaintiff's husband, child, and stepchild, really was kind of the unspoken trial of the case. The reason I say that is that much of the emphasis that the plaintiff brought with respect to the supposed misrepresentation which occurred dealt with what happened and the causation of the collision itself, as the court's aware from the briefs. The issue of whether the obstructions on the two roads where the intersection occurred where the collision took place was an issue that was significantly discussed in trial. The issue of whether the driver of the PAL bus insured by National Indemnity had been subject of a positive drug test. The issue of whether the driver had been speeding. There was really no dispute as to the fact that the driver, the plaintiff was employed, was controlled by a stop sign and was in the intersection when the collision took place. Those points, the points of positive drug tests, the speeding, and the obstructions, became the feature for what then became the fraudulent case trial thereafter, after this case was settled. Now, with those points having been stated, the case then was litigated substantially on issues of documentation. And there are numerous issues raised in this case with respect to whether documents were preserved or not preserved, whether they were available or not available, and various sanctions that were imposed. One of the issues that we raised here today is that, say, prior to trial, the trial judge then presiding in the case announced that he would provide what's known as a Valson-type instruction, which was certain referred to as claims diaries. And there was disputed testimony as to whether these claims diaries on the part of the Micros here existed. Although no Valson instruction was actually given, we submit that that ruling allowed a significant amount of testimony at trial to come in with respect to the manner in which the documents were produced or not produced, things of that nature. Now, under the case law, the appropriate method for handling these kind of problems is either dealing with having those documents admitted or not admitted, but not making them a feature of the jury trial itself. And we submit that one of the most errors here was the fact that the case became really a trial about whether claims diaries existed or not, and these other types of matters. There's no question that the defendants were sanctioned, and their case was inhibited as a result of things that occurred. For instance, there were 4 documents that were on attorney-client privilege law that were allowed to ultimately be discovered at the initial trial. There were additional 12 documents on a subsequent motion that dealt with privilege issues which were allowed to be admitted. And perhaps most significantly, and what the trial judge thought was the straw that broke the back, if you will, was the issue of statements that had been recorded by some of the passengers of the PAL bus, which the defense lawyer didn't have literally until the time of trial. That was what ultimately caused the court to give what he called a Balson-like instruction. Not a Balson instruction. Counsel in his brief took us to task for saying there was no Balson instruction. Never said there was. But the fact that there had been a pre-trial ruling that a Balson-type instruction would be given at trial was significant because it turned the trial not into whether Nikos and the lawyer for Nikos had, in fact, been engaged in an attempt to either hide information or not disclose appropriate information, but the case got tried on a variety of other issues.
What information do they have to disclose to this plaintiff?
Well, that was a hotly contested issue, Judge, and part of it because of some disputed facts as to what the plaintiff knew. The record reflects, although there was some slight differences to when the Florida Highway Patrol informed the plaintiff, but it was either right before or right after the funeral, but before the first meeting that any representative of the insurance company had with the plaintiff, that in fact the PAL bus driver was speeding. And that was part of that.
Well, I mean, they didn't pay her money, right? Obviously, when they settled the case, they admitted they might have some potential liability, but what specific information do they have an obligation to come forward and tell the plaintiff when they're sitting down to negotiate a claim?
Well, as I said, the plaintiff was already aware of the speed, and there's testimony in the record from Ms. Warwick that she talked about speed.
But even if she wasn't aware of the speed, did they have to tell her that they think their bus driver may have been speeding?
Well, that is one of the disputed issues, Judge, and I think under the law, we have a problem here. This is not a first party. They are at arm's length. They are clearly not in a fiduciary position.
So there's no duty to disclose anything, is there?
Well, there are certain duties under what the Code of Adjusters' Conduct, which was another issue that the plaintiff attempted to get into at trial. And there was some dispute as to whether that was applicable or not. But the point here is...
What under Florida law?
Well, under Florida law, we believe that the first duty that the carrier and its agents have is to its insured, not to the third party. And the problem here, and this was one of the friction points in the case, was that the duty to the insured to not disclose information rubbed up against the claim that, well, you misrepresented things. We don't believe that and that's one of the things that was reflected in the summary judgment motion.
Was there any evidence of an affirmative misrepresentation? Were there allegations or proof that was there proof that we had here more than simple non-disclosure?
The only, Your Honor, from my review of the record, the only thing that I could suggest, and your counsel help me answer that question, is not correct. When Ms. McLoyd testified at trial, as opposed to her testimony in her deposition, she said that on the second meeting, there was a meeting on January 27th, and there was a subsequent meeting February 12th of that. At the second meeting, the plaintiff had already learned of what the term street talk, that the driver may have tested positive for drugs and a urine test that was taken right at the accident. And she testified that she asked Mr. Warrack, was there, I've heard this street talk, and my recollection of the testimony was that the reply that the plaintiff testified to was that was unsubstantiated. Now, the reason I think that's the best they get, and the reason that I think is not necessarily misrepresentation is there was never, at any time in this case, ever a quantitative value as to what was in the system. Dr. Tomasino was the physician who actually reviewed the results.
But the insurance company did know that blood tests.
Not blood, Your Honor, urine. Yes, sir. And that's significant.
Revealed that at some time the driver had ingested cocaine, smoked marijuana.
At some point, and what I was going to say is that Dr. Tomasino testified that only showed that there was a presence. That cocaine can stay in the system for 5 days, and cannabinoids can stay in the system for as long as 30 days, and there was no evidence, and this is the significant part of the claim, no evidence from any of the witnesses at the accident scene or thereafter that Mr. Williams, the driver, was impaired. And this included the Florida Highway Patrol officer who investigated the crime scene, the PAL folks who actually administered the urinalysis. Nobody found him to be impaired.
So let's assume that okay, he has the cocaine in the system, the marijuana system, whatever. Does the insurance company have to tell the plaintiff that they have this information.
Again, I believe that they don't, because their ultimate duty has to flow to their insured.
And
You're not saying they're entitled to affirmative misrepresentation.
No, and I don't think there was misrepresentation here, because what did the word say? It was not substantiated, and because in her mind she knew that all the testimony or the evidence that had been gathered at that point by the investigators and the other folks that were out at the scene was that he was not impaired. There were no signs of impairment, no signs of erratic behavior. He was distraught, obviously, because he was involved in the collision, but there was no evidence of any impairment.
Highway Patrol isn't arresting.
Oh, no. No, Highway Patrol, in fact, the trooper testified at some length about the fact that he was not jittery, he exhibited none of the signs. There was a lot of testimony about, well, there would have been no odor, there's no alcohol impairment. One of the prime points of evidence is odor about alcohol, things of that nature. Well, there wouldn't be odor, but all the other signs would have been there, and none of them were present with respect to driving. See, I'm using my all the time. Thank you.
Please support Phil Burlington here on behalf of the employee of the council table as trial counsel, Dr. Regional David Drummond. I'll address the issue about the Val Sandy instruction that we have given and the document issues. They were not the feature of the trial, but they were an integral part of it. So as, for example, Plaintiff Exhibit 3 stated on its face that they had communications between them saying they had the drug test results, they had them under wraps, and all the copies had been given to Mike Colson, who was the attorney for National Indemnity. We were never able to get those from them. We ended up having to get them from a third party. There was testimony regarding Mr. Colson admittedly purging his file. He was unable to answer with any degree of coherence the jury's own question as to what his firm's policy was on destroying his file. And he also testified that he knew he had the drug test results.
So before they sat down with this plaintiff, they should have told her that they had information that he may have had drugs in the system.
I am not saying they had to volunteer any information, but let me point out.
And they should have told her that he may have been speeding.
I'm not saying they had to volunteer any information.
So they had no duty to disclose anything to her.
They did not have a duty to voluntarily disclose information, but they started out affirmatively misrepresenting. If they had a witness that she ran the stop sign, in fact, she did not. In fact, what they tried to say was somebody on the bus saw her run the stop sign, when they knew they had already taken tests at the scene, that there were visual obstructions that the people on the bus could not have seen what happened with the stop sign.
So if a plaintiff ever settles their case without an attorney, and then they later find out that there was information that the other side had.
No. And let me add, none of these questions, which I'm very willing to answer, have to do with any of the issues they've raised. They have not raised directed verdict on the fraud claim. They have not challenged any of the admission of this evidence. They have not said it's against the manifest way of the evidence on the fraud claim. So while I'm willing to answer any questions you have factually about the misrepresentations they made, for example, there was a fundamental misrepresentation that they went to the meeting not to settle or engage in any of that. It was what they called a meet and greet, and they got right into it. There was also evidence about the adjuster's code of ethics, that they are barred from trying to negotiate with somebody who is in obvious distress from the trauma relating to the accident.
What is the adjuster's code of ethics? Is that Florida law?
Yes, that's a Florida statute. And here, this was a rather unique scenario because there were two adjusters from Allstate who were Larose's own insurance representatives who were there to talk to her about her PIP coverage, what they could do to help her. And both of them testified that it was their understanding, and they had told Larose and Larose's mother that these people were just coming to express their condolences. And they were both shocked, and that's their terminology, that this insurance company went right into telling her that she ran the stop sign, she was primarily responsible, she needed to accept that. They were there to help her. They were asked, do I need an attorney? Oh, no, you don't. We're here to help you. And then they proceeded to basically overcome this woman who was in the most dire emotional straits. And even independent of Dr. Rando's testimony, which they challenged, there was an evaluation done at the hospital by Dr. Camilla Scott that found that she was suffering from acute depressive disorder. She was unable to emotionally analyze the information she was being given, And it was apparent to the Allstate adjusters, and in fact the Allstate adjusters got in a shouting match with National Indemnity's people on the lawn outside about how they could not believe that they came to this meeting and tried to overcome this woman and misrepresent to her and take her at a time when she was clearly unable. She was on medication. She had a fractured hip in the accident. She was emotionally distraught. And they were trying to push this issue of, it's your fault, we have information. And there was testimony, and it is disputed about whether there was a question asked as to whether the driver had any drugs in her system, and they said no. And now there is a dispute, but obviously as appellee, I'm entitled to that evidence favorable to me. But again, none of these facts...
He said that's not exactly what the answer was. The presence of drugs was not unsubstantiated.
Well, when they say unsubstantiated, they had... See, this was a drug test required to be taken by the DOT, and it came up positive for both marijuana and cocaine. And both Colson and Dvorak admitted they knew that at the time of the meeting. And they had it, and to say, what he's saying was unclear was, well, the PAL employee who took the driver to take the urine test said, well, I didn't think he was impaired. Well, he's a PAL representative. What are the chances that he's going to say, yes, our driver was staggering?
Well, how would patrolman would have said it if he noticed it, wouldn't he?
Well, we don't know. He did not testify at trial, and we don't know how long it took him to get there. But regardless of whether it was clearly apparent to the people at the scene, the fact is, and what's probably more important is, the evidence of speeding was so overwhelming, and they knew that at the time. And when they tell this woman that she's primarily responsible, she made the stop sign, we have a witness, that is false, and it was done to engage in fraud. But
They did not have a witness. They could not identify.
their own information was, their story was somebody on the bus saw that she ran a stop sign. But their own information said there were trees that were obstructing so that she could not see the bus where it was speeding at 50 miles an hour, and the people in the bus could not see her at the stop sign.
So there was nobody on the bus that said she ran the stop sign.
Right. They did not, well, no evidence went into trial on that. And they said they knew at the time because they had gone to the scene.
So you're saying that all the evidence that was adduced, the jury was forbidden to find, and they knew there was no witness during the stop sign, and they told her there was.
Yes. And they told her it was primarily her fault. But again...
Well, she did have a stop sign, right?
Yes, she did have a stop sign. But the bus, as they acknowledged, with their most favorable calculations, was doing 47 miles an hour in a 30-mile zone, and the witness on the bus said the driver wasn't even looking straight ahead, and they had to bring his attention to the fact that the car was up there. And their own reconstruction prior to meeting with our client indicated that if he had been doing the speed limit, he could have stopped at either 3 or 6 feet before the vehicle, and there would have been no collision. And they knew that when they talked to her. But
aren't you right that the jury might well have been confused? We spent all this time at trial talking about discovery in your case. They might have used that information to decide to question about the variety of company behavior at the time.
no, Your Honor, because, first of all, there was never any discussion of discovery per se in the way of any of the sanctioning. That was never mentioned to the jury. What came out in the context of their own memos, for example, tying up all the drug tests. Colson has all the copies. And then, when we were asking Colson about his file, and then he purged it, that came out. The jury never heard anything about the pre-trial discovery. And it was not a feature of his 1,400-page transcript.
So realistically, plaintiffs don't need to get an attorney when they get injured. They can just go settle their cases, and years later they can, come back in. And if there was anything that would have enhanced their case, they can come back and retry the case.
Absolutely not. And that has never been our position. And it doesn't relate to any of the issues they've raised. Here, it was formal. And again, they've never challenged the sufficiency of the evidence or the manifest weight of the jury's verdict in this case as to fraud. Because they know we proved fraud. This is not a situation where some plaintiffs settled the case and then learned one fact and came back and said, I want to do it. This was a woman who was in no position to engage in settlement. They knew it, they pushed it, they misrepresented to her, and the jury was entitled to find.
But realistically, when would this plaintiff have ever been capable of settling this case? Ever?
Once she got in.
I mean, this is a multi-million-dollar case. You think that she is qualified to settle this case at any
Once
given
she got
point?
an attorney, and perhaps with
But she didn't get an attorney. She chose not to. She wanted to save the attorney's fee or something.
No, she did not want to save the attorney's fees. What she testified to was, because the information had been put out that she might be charged, and that was never eliminated, she told her mother, because these people were from the police athletic league, that she said, if I don't cooperate with them, I'm afraid I'm going to go to jail, because she heard on the television at the hospital that the driver of the vehicle was being looked into to have charges brought against her. Now, once she got an attorney, and he could evaluate her condition and or get some type of, if she was in really bad
She
shape.
would have never been able to settle this case, though, right?
Yes, yes.
When is a plaintiff qualified to settle this kind of case when they're not trained in the law?
When they obtain an attorney, and he takes the approach, he or she.
Okay, when she obtains an attorney. So basically, the insurance company can never settle with a plaintiff who doesn't want to get an attorney, if it's dramatic and serious and
This woman, the testimony at trial from our expert, Dr. Randall, was even.
That's the grief guy?
Excuse me?
That's the grief guy?
That's the Greek lady, yes. And she's board certified in that subject. She evaluated her 6 years later and said she is still operating at 45% of her cognitive capability because of how devastating this whole process has been. But this woman needed an attorney. There are plenty of plaintiffs who can resolve cases without attorneys. But even if they had done it without defrauding her, I would be in a very different position. But the evidence was clear that they misrepresented to her. They set her up. They told her she didn't need an attorney. We're here to help you. And they misrepresented the information regarding the accident. But to deal with the issues in this case.
But one of the amount of what basis you get for this policy limit?
Because there was no evidence at trial at all that the policy limits were a relevant consideration in the jury's deliberation. Their own expert testified that he valued these cases in the range of 2 to 3 million. Our expert said 4 to 5 million. Their expert was specifically asked, what about the insurance policy limits? He said, well, I really didn't consider that. I didn't really think about that in doing my analysis. I didn't think it was relevant. And I quoted that in my brief. So there was absolutely no evidence. They never made a motion at trial for directed verdict. And they simply have not preserved that issue. But the point is, this entity, and then its testimony, operated with its own funding, had its own vehicles, had its own building. So to say that the only assets available for a settlement was the insurance policy would be factually incorrect. But their own expert eliminated that argument, and they never properly preserved it. So that
Did they move for the
they did move for remitted, which would be based on a manifest way of the evidence argument if the award was successful. But when the evidence they put on, the jury essentially accepted their expert's evaluation of 3 million. Who said 2 to 3, ours said 4 to 5. So how could they say it was against the manifest way of the evidence when they put on an expert that said it was in the range of 2 to 3 million? There's no way that could have been excessive under the evidence they put in. So the trial judge correctly, the trial judge did not abuse his discretion in declining the remitted when their own evidence undermined the argument. I would like to touch briefly on the cross-appeal question. I previously asked for 2 minutes to address that on the rebuttal. We have asked that an additional element of damages the trial court did not allow us to pursue, which was the intangible damages, otherwise known as pain and suffering, or client suffering. In a situation like this, the way under the jury instructions given, the only compensatory damages we were allowed to recover were the damages that they should have paid if they had not defrauded our client. There is no deterrent for someone engaging in such conduct unless there are damages greater than that. I have cited the Food Fair versus Anderson case, which I submitted directly on point, where a lady was defrauded, and it was done in a malicious manner, and the 5th District held that in those circumstances, the plaintiff can't get an award for pain and suffering because of the malicious nature, if it is sufficient to allow the consideration of punitive damages, and that occurred here, albeit the jury found it award. But I'd like to reserve the remainder of my time on the rebuttal.
Remarks, if I might correct something the counsel said. Corporal Williams did in fact testify at trial, and his testimony was significant because he and Corporal Mears were the ones who actually did the investigation of the accident scene. Find his testimony being on page 1932 of the transcript. So there is testimony about the lack of impairment evidence, and it wasn't just insider. Counsel talked about Dr. Rambo, and I didn't get a chance to refer to that, but I do want to take a moment to speak to Rambo. Angren v. Key is, I guess, the lead Supreme Court case on the issue of whether brief or bereavement experts should come in. We believe that under Angren v. Key, Dr. Rambo should never have been allowed to testify. All she did was she bolstered the testimony of lay witnesses and the discharge information from Dr. Scott, who interviewed the plaintiff on the day that she was discharged from the hospital. 8 plus years, not 6 years, by the way. Dr. Rando didn't actually do any work on this case until the summer of 2007, right before the trial. This is unlike the situation in Portland v. Channing, where there the psychologist not only was testifying about the impact of the family, but was actually the treating psychologist of the family. Rando treated nobody other than the plaintiff's trial case. They didn't provide no clinical effort whatsoever. The other thing that's significant about Angren, I'll just touch on in a minute, it says, well, will allow either a treating medical professional or someone who reviewed the records of treatment. There are no records of treatment in this case because the plaintiff got no treatment after her discharge. The only medical notes that are ever referred to in this case was the discharge summary from Dr. Scott, who counsel referred to, who said that
Was allowing your testimony harmful error?
well, it absolutely was, Your Honor. In fact, there was discussion about whether it was cumulative and still harmless. No, because Dr. Rando was referred to repeatedly in the closing argument. Rando's testimony took about 175 pages of the transcript. Rando was taken. Rando did nothing but repackage and bolster information that was already available. Who did she talk to? She talked to the aunt, she talked to the pastor, she talked to the uncle, she talked to the plaintiff. And all she did was use a mouthpiece for saying, well, the plaintiff thinks this happened to her, the plaintiff thinks that happened to her, the aunt thought this happened to her. It was harmful because, as the case law states, it allowed the jury to somehow think this is more significant than it is. It's a sad circumstance, but these things happen, and it's within the normal experience of lay jurors.
Are they entitled to more than $1 million policy limits?
No, and that goes to the remitter issue. And Coker, who was the plaintiff's witness, didn't say it was a $5 or $6 million case. He also adjusted for the comparative negligence of Ms. McLoyd. The high end for both Gerard and Mia's claims, he had was $3.05 million. High end. After he applied what he considered to be a comparative negligence factor. Our witness, Mr. Fisher from Orlando, said that the numbers were not appreciably different. The difference was he had described a much higher comparative negligence quotient. So when they say, well, he never dealt with policy limits, he never had to, because he valued the case as less than policy limits because Mr. Floyd had violated the right of way. And then the other, so as to that, the idea of a fraud case is to put the plaintiff back in the position it could have been. Let's say that she hadn't been frauded, if you will. If she chose not to prove her case, not to settle her case, if she wanted, she could have hired a lawyer. And for them to say, well, we could have got an excess judgment. Well, even Mr. Coker said that's unlikely. He said, how do cases get settled? They get settled, in the unusual case you might go above limits, but this is not a bad faith case. There's no bad faith here. You're in arm's length. So even Mr. Coker acknowledges that policy limits do have a role here. And here, what Ms. McLoyd has gotten is not only the benefit of the settlement, approximately $435,000, which that's what the jury was instructed. They're supposed to set that off. I don't know how they can get set off and get a $3 million verdict when the high end of your own plaintiff's expert says it's 3.05 on a set off. That was the basis for the commitment. But also, there's no basis for saying that you should improve your position. Finally, I'll address briefly the comment on the cross appeal. Counsel, I don't think it was inadvertent. He said the reason they should get pain and suffering is supposed to be a deterrent. Use the word deterrent. Deterrent sounds to me like punitive damages. Punitive damages were rejected by this jury. All the cross appeal is a backdoor effort to try to obtain punitive damages in a case where the jury's already considered them, rejected them, and under the same Regis they cited in our brief, they can't appeal that. So now they're trying to basically go to the back door and think that we're trying to see my time is expired. Thank you.
Those on your cross appeal, counsel?
Yes, when I said it as a deterrent, obviously, in any tort action, compensatory damages serve two functions: to compensate the plaintiff and to deter such conduct. Yes, the punitive damages are not an issue here. However, her pain and suffering in this case, and what they made her feel for over a year and a half, that it was her fault for the death of her husband, her child, and the other child that was in that vehicle, is the type of pain and suffering that goes well beyond any type of emotional loss that is normally involved in a case involving fraud. This is an extraordinary case. They beat this woman down emotionally, they took advantage, and obviously by the fact that the trial judge ruled we were entitled to present the issue of punitive damages, that gets us directly within courtesy of Jernigan, it gets us directly within Food Fair versus Anderson, and the other Supreme Court case of the court. That was the kind of conduct here that was outrageous, and the jury chose not to award punitives, and that's fine. That's a discretionary call. But we are entitled under the existing case law. I'm not asking you to make new case law. I'm saying from those three cases that we cited in our brief, this is precisely the scenario where pain and suffering damages are a culpable or fraud action, and their conduct created pain and suffering beyond simply the type you would have from a financial loss in a normal fraud. That's what the case law holds right now, and we are simply asking for truth. Thank you.
Ladies and gentlemen, the court will stand in recess for about 15 minutes to have coffee in the Dean's Suite, and the clerk will tell you how to get there. It's on the third floor of the 370 police constable.